Criminal prosecutions are one of the most important aspects of the justice system in America. This video explains some of the customary steps in the criminal process in Missouri to help inform journalists in connection with their camera and/or audio coverage of Missouri criminal cases. Criminal cases come in two levels of severity. The less severe charges are misdemeanors and infractions, which are punishable by a fine and/or jail sentence. The more severe charges are felonies, which are punishable by a prison sentence and/or fine. Criminal cases begin when a prosecuting attorney brings charges. The charges can be made by the prosecutor himself or herself, then they are called an information, or by a grand jury, in which case they're called an indictment. After the defendant is arrested or voluntarily surrenders himself or herself, he or she is brought before a judge for an initial appearance. Here the defendant is informed of charges against him and of his right to counsel. Conditions of custody or release are set. The next proceeding, an arraignment, is scheduled. The Missouri Cameras in Court rule prohibits any camera coverage of proceedings in which a criminal defendant is not represented unless he has waived his right to counsel. The arraignment usually comes a few weeks after the initial appearance. That's where the charges are formally read to the defendant. The defendant enters his plea. The court may set a trial date and hearing dates on pretrial motions, either at the arraignment or later. The defendant can plead guilty, not guilty, or no contest. If charges were brought by information, the defendant is entitled to a preliminary hearing in which a judge determines whether or not there was probable cause to find that a felony has been committed and that the defendant committed it. The prosecution presents evidence. The defense can, but usually does not at this stage. If the charges were brought by an indictment, no preliminary hearing is required. Often guilty pleas are entered at or after the arraignment. The entry of a guilty plea occurs in open court. Before accepting a guilty plea, the court must address the defendant and make sure he understands the nature of the charge, the range of possible punishments, the right to legal counsel, the right to a jury trial, and the fact that a guilty plea waives these rights. The court must determine that the plea is voluntarily given and that there is a factual basis for the admission of guilt. Many guilty pleas come about through plea bargains. In plea bargains, the prosecutor and defense counsel may agree to dismiss other charges, not oppose a request for a particular sentence, agree on a particular sentence, or recommend an appropriate sentence to the judge. Plea bargains must be disclosed in open court. A variety of pretrial motions may be raised in a criminal case. Often the defendant moves to suppress evidence. A motion to suppress is a motion to keep something out of evidence. The defendant may move to suppress a statement he made, alleging that it was obtained through force, without adequate Miranda warnings, or after an illegal arrest. He may move to suppress illegally obtained evidence, such as through an improper search. He may move to suppress an identification on the grounds that a police station lineup was unduly suggestive. Some testimony may be offered, but usually these hearings consist primarily of legal arguments. If the case proceeds to trial, the defendant has a constitutional right to a trial by jury. In Missouri, juries consist of 12 members. If a defendant consents, he may waive his right to a jury trial and allow the case to be tried to the court, that is, by the judge. Jurors can never be photographed in court by media cameras. Witnesses at trial can include victims, eyewitnesses, police, and experts. Some witnesses, with special situations are concerned, may be treated specially by the Cameras in Court rule. For example, juveniles, undercover police, and rape victims whose testimony in some cases cannot be recorded by media cameras or audio equipment. The defendant has various rights at trial. the defendant is presumed innocent unless and until the jury finds him guilty. The state has the burden of proving its case against the defendant. In a criminal case, there is never a burden on the defendant to prove his innocence. The state's burden is defined as, quote, beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. The law does not require proof that overcomes every possible doubt. By contrast, in a civil trial, the burden is usually, quote, by the preponderance of evidence, a lower standard. The defendant also has a right to confront and cross-examine witnesses. The United States and Missouri constitutions require that evidence presented against the defendant be given in the defendant's presence. The defendant also has a right to remain silent, guaranteed by the U.S. Constitution, the Fifth Amendment, and the Missouri Constitution, Article 1, Section 19. Often, a defendant will not testify because he does not want his prior criminal record to be known. If the defendant takes the witness stand, his criminal record may be revealed for the purpose of impeaching his credibility as a witness. If the defendant does not testify, the court and prosecuting attorney cannot comment on it or try to have the jury infer guilt from the failure to testify. After all the evidence is submitted and the jury has heard closing arguments and the judge's instruction as to law, the case is submitted to the jury. There is no fixed limit on the length of time for a jury's deliberation. The length of time is within the discretion of the judge. The jury's decision at the trial is the verdict. A verdict must be a unanimous decision of the jury. If the defendant is found guilty, in Missouri, the jury has the primary responsibility of assessing punishment, but the judge gives the final sentence. Sentencing usually occurs in open court several months after the end of the trial. A pre-sentencing report will be done, and the judge will rely on that, as well as arguments of counsel for both sides in setting the sentence. In a sentencing hearing, it's up to the judge to give the final verdict. If a jury sentenced the defendant, the judge cannot increase the punishment specified by them, but can reduce it. The defendant could be jailed, imprisoned, or placed on probation. If the defendant is imprisoned, the sentence will state how long the defendant will be imprisoned with a specific term of days or years. If the defendant is found not guilty or acquitted, the state is barred from retrying him on that charge. That's the right of double jeopardy. This video has helped illustrate some of the basic processes for a criminal case in Missouri. We encourage you to do your own research, where you should find the Missouri Press Bar Commission's Reporter's Handbook on the Courts and the News Reporter's Glossary of Legal Terms, which should both be very helpful. Most prosecutors and criminal defense attorneys would also be happy to talk with you about criminal procedures, even if they don't want to talk about the specifics of their cases. On behalf of the Missouri Press Bar Commission, we thank you.